Ladies and gentlemen, I welcome all to my channel. Today we are going to see the nomination and the term nominee, which is used in bank account and in employment registers. Normally, when you open a bank account in your bank, whether it be a current account or a savings account or a fixed deposit, the bank authorities used to say, or they used to request you to give a nomination and to nominate a person as a nominee. Who is nominee? What is meant by nomination? What are the legal effects of this nomination? And we are going to see all these things in this video. If your person nominate his wife, son or daughter as a nominee in the bank account, it means that in the event of his death, the person nominated as a nominee is entitled to receive the amount lying in the bank account or in the company where he is working. If you make a nomination in the bank account, the nominee is entitled to receive the balance amount which is available in the particular account. Similar way, if a person is nominated in a government, which is supposing a person is working in a government service, either in a state government or federal government or in any company, and the employee nominates his relative, whether it's a wife, son, daughter or any other person as a nominee, in that case, in case any death happens, the person who is nominated as nominee can collect the salary dues, settlement benefits, gratuity, pension or any other benefits, retirement benefits or death benefits, which is payable to the deceased person. So the nominee is a person appointed by the person who died to receive or to collect the amount or any other benefits which is receivable by the deceased. So what is the procedure? In bank, if you want to make a nomination, you can go and ask them a form, nomination form. You can just fill the form and you can just name the nominee and also specify his age or other details and also the relationship between you and the nominee. So the procedure will be complete. In case of a company or in case of a government service, you can just make a request. You can just submit a requisition letter requesting the authorities to register the nomination, and you can simply say, my son, Mr. X, will be a nominee to receive my salary to receive any benefits from the company or from the government in the event of my death. So it does not require any formal stamp paper, does not require any agreement or does not require any other legal formality. Simple letter, simple requisition letter is sufficient. So now the next question is, now you understand how to nominate a person. Now what is the next step is, what is the legal effect? Once this nomination is done, automatically the bank or the government will disperse, will hand over, will give the money or salary benefits, salary dues, other benefits to the person who is nominated as nominee. So they need not follow your stringent rules, because it was already an authorization. Nomination is nothing but an appointment or authorization given by one person nominating one person. So once the nomination is done properly, the bank or the government will not have any difficulty in handing over the available fund or money to the person nominated without any difficulty. Normally, when a person dies, automatically, whether it's a bank or in the government company, automatically they used to ask the death certificate and the legal care certificate, and also the requisition letter signed by all the legal heirs. In bank, they used to give a form, claim form. In the claim form, they will ask who are all the legal heirs. Then I will also ask the signature of all the legal heirs persons. Then there would be a declaration saying that all the legal heirs have no objection for granting this money lying in the bank account to the so-and-so person who was appointed as a nominee. So after collecting all these forms, the bank automatically hand over the money to the nominee. In case of the employment, the company or government automatically hand over the settlement benefits, salary rates or other retirement benefits to the person who was nominated as nominee. So now you may ask a question, what is the difference between nomination and without nomination? What will be the consequence if a person is nominated as a nominee, or if no person is nominated or no nomination is done? In both cases, the procedure followed is same. Even if a nomination is made or even if nomination is not made, the bank used to ask you to produce the death certificate. The bank used to ask you the legal care certificate. The bank will also ask the consent, requisition of all the legal heirs to return the money to any particular person. In the event of a nomination, the bank will give the money only to the nominee. In case no nomination is done, then the bank will give the money to any one of the person who was authorized by all the legal heirs. Supposing all the legal heirs authorizes one of the person, whether it is a mother or elder son, then automatically all the legal heirs has given their consent, the bank will issue the entire amount to the one particular person. Supposing all the legal heirs requested to divide the amount and to share the total amount to all the person, in that case also the bank will do the same. So the procedure followed in bank and in government services in dispersing the amount, in returning the bank deposit, it is one and the same. But the bank has their own rules. Every bank has their own rules. When the amount is very low, say below 1 lakh or below 50,000, they simply will ask you legal death certificate, legal care certificate, and they will also ask the requisition of all the legal heirs signature, and also request you to produce all the ID proof of all the legal heirs certificate, all the legal heirs. So on the basis of that, the bank will disperse the amount lying with them. If the amount goes high, then the bank used to ask you to produce an order from the court. It is called as succession certificate. So in that case, supposing the amount is 10 lakhs or 20 lakhs or 1 crore, 20 crores, then the bank will say you get an order from the court, then only we will disperse, because we don't want any risk, like that they used to say. Then we will have to apply a certificate called court order, which is called a succession certificate. If it is in Chennai, we can file this petition in the High Court, and we can get a success certificate. If it is the place of death is somewhere else other than Chennai, then we will have to move in the concerned district court to get the success certificate. Then what is the procedure followed what is the procedure to be followed to obtain such success certificate? So in case all the legal heirs are cooperative to each other, they can file a joint application, one single case, and they can jointly request the court that we are the only legal heirs, and you can request the court to issue the success certificate. So on the basis of the joint requisition, the court will hear the case and dispose the matter and pass the judgment or order or issue success certificate within 3 months or within maximum 6 months. Supposing some of the legal heirs are not cooperating, and some of the at least one or two of the legal heirs are not joining in filing this case or petition before the High Court, then the person who are ready to sign the case paper can file an application, and they can implead the other person who did not sign the document as a respondent or defendant. So in that case, the court will take this matter as a contested case, and the court will hear both the parties, and give judgment and issue certificate on the basis of the inquiry conducted by the court. So if all the persons join together and file a petition, it is easy for the court to consider the application, to dispose the application, and the court will issue the success certificate within 3 to 6 months period. In case all the party did not cooperate, then automatically it will take a long time, because supposing there are 5 persons, 3 persons files this application to issue a success certificate, then the court will number it as a case. The court will issue summons to all the parties. The court will issue notice to all the parties, the other parties. Then they will have it is to be served to them. Then other party will come and appoint advocate. Then they may file a counter or objections. Then the court will hear this party, one party, and they have to produce evidences. Then the other party will have to produce their evidences in support of their stand. Then after hearing both parties and the arguments of both the advocates, the court will come to any conclusion and pass some judgment, order, and on the basis of that, success certificate may be issued or the application will be dismissed. So for these things, it will take time. If the success certificate application is filed jointly by all the co-legal heirs, you can get it easily. Otherwise, it will take a long time. Now, you will be asking one question. The procedure followed by the bank for nomination and the procedure followed by the same bank to the cases where no nomination is done is one and the same, then why should you insist for nomination? See, once the nomination is done, in that case, the bank will not have any difficulty in returning the amount to the concerned nominee. So already the account holder has already appointed or nominated one person. So on the basis of the nomination, the bank the duty of the bank is to verify the identity of the concerned nominee, and they will insist him to produce their ID proof, address proof, or any other document to show that he is the nominee. Then after verification, this aspect, they can disperse the amount, and they can give the amount, and they can close the case. In that case, the other legal heirs cannot go and question the bank. They cannot, because already nomination is done by the account holder. So there will not be any difficulty to the bank. Secondly, suppose the bank has insisted too many things, too many procedures, too many stringent rules, then we will also, the nominee will also have a right to make a claim as against the bank, and we can insist the bank to give the money without demanding unnecessary documents and without insisting unnecessary procedures, unnecessary stipulations. So supposing the bank asks you to produce succession certificate, if the nomination is made, then we can directly blame the court. We can insist the court. We can pressurize the court. Why are you asking the succession certificate? It will take a long time. It is not my job. Already nomination is done. I am the concerned person. You personally verify me and you issue me return me the amount. Like that we can question. We are legally entitled. If the concerned bank refuses, then you can also make a complaint to the higher authorities, or you can also insist Ombudsman Bank or RBI and also the Consumer Court to disperse the amount immediately without any further delay. Because as a matter of right, we have the nominee is entitled to receive the amount. The last aspect is, who is nominee? Whether he is entitled to take the entire amount or he has to disperse the amount to all the legal heirs. The nomination means he is a person appointed as a nominee to collect or to receive the amount. The nomination does not mean that the bank account is gifted or bequeathed or settled on the nominee. There is a difference between gift, settlement and nomination. Supposing a person nominate his first son as a nominee, the first son is entitled to collect the amount from the bank. He is entitled to receive the amount, but he cannot take it, he cannot own it for his own purpose. He has some duty. He has to disperse the amount, share the amount with all the legal heirs. Suppose the elder son was appointed as a nominee, he can collect the amount. Suppose the father has any obligations, debts, he can clear those debts and obligation. Suppose the father has any obligation that out of the amount, he can give priority to the clearing the debts, he can clear the other obligation. The remaining amount has to be shared, divided, dispersed, given to all the legal heirs as per the law. Supposing a person died, is a Hindu, then all the legal heirs, first class legal heirs, second class legal heirs, are entitled to receive the proportionate share as per the Hindu Succession Act. Similarly, if a person died is a Muslim or Christian or Parsi or any other case, their personal law, namely Muslim law of inheritance, Christian law of inheritance or Indian Succession Act, the concerned law will apply, and as per the shares mentioned in the particular law, this amount has to be dispersed, divided, shared among the legal heirs. So, I wanted to make it clear that the nominee is not a person who is entitled to take the entire amount. He cannot swallow the entire thing. He cannot own the entire amount. His job is that he is only a person appointed to receive and collect the money on behalf of all the legal heirs, and he has to disperse it to all the legal heirs. Supposing he did not disperse, does not share, did not give proper share to the legal heirs, then it amounts to an offence. It amounts to misappropriation, criminal misappropriation. You can also give a criminal complaint. Supposing a son is appointed as a nominee and he received the entire amount from the bank and did not share the proper share to all the legal heirs, then the legal heirs can also file a case, and they can also give a complaint to the police for the offense of criminal misappropriation, cheating, criminal breach of trust, like whatever the criminal offenses will come under this category. So criminal case can also be filed as against nominee in case he fails to disperse the amount to all the legal heirs. So I wanted to make it clear that it is always better to make a nomination. If the nomination is done, it will be helpful not only to the bank, it will also helpful to your children or legal heirs to receive the amount without any stringent formalities, without any difficulties. In case the bank insists for any stringent formalities or court order or another thing, at that time also you can pressurize the bank to return the amount without any such stringent formalities. And one more clarification I wanted to make it through this video is that the nominee is not entitled to take the entire amount. He is only a mediator, he is a middleman, he is only a public officer, he is a common man to collect the amount and to disperse the amount to all the legal heirs. So he cannot take the entire amount for his own purpose. I hope this video will be useful to you. So if you have any opinion about this video, you can make your comments in the comment section. If you really like this video, you can give a like. It will give me an encouragement, and you can watch my video continuously by watching the legal video. By watching my videos, you will not only gain knowledge, you will also get power and confidence. If you want my tips in Tamil, you can watch my Tamil channel Raziaq, Sattam, Arivom. If you want in English, you can watch this Raziaq Law Tube. If you have any doubts, you can open any of my channel and you can go through the playlist, or you can go to watch. You can see the relevant topic and you can clear your doubts. In addition to that, if you want any personal legal opinion or consultation, you may also contact me in person or over phone, and you can get consultation or legal opinion for any subject. I hope this video will be useful to you. I will come again with another topic. Till then, goodbye. Raziaq Ali.